I know, but why would he search him?
What?
I get it on the driver because he sees the hand-to-hand contact with them, but he's just sitting there.
These corrupt cops thought their badge gave them power over everyone. But inside the courtroom, the judges flipped the entire script and left them completely humiliated.
The only thing would be officer safety, just the pat down.
In February 2025, a black man was thrown behind bars for absolutely nothing. He wasn't even driving, just sitting in the passenger seat. Yet somehow, that alone was treated as a crime.
You made it out.
Just
We're not asking for much, man. Just be careful, behave, don't do anything you shouldn't do, you know? Is those cases are still open in Fort Bend or what?
The case is still open in Fort Bend. It's still pending. Your next court date is down there.
it's on March. Not all the cases are open.
One of them's still open. Paul two's representing him. I talked to Paul yesterday, and it's set for sometime in March. I can't recall the exact
It's okay.
date.
To do probable cause, you have the right to remain silent. Anything you say can and will be used against you. I just want to see if there's enough to go forward on your case. I don't know what happened. Okay, Alex, please.
Yes, Judge. On September 4th, 2024, the officer observed a hand-to-hand transaction between the driver of a parked vehicle and another individual. The defendant was a passenger in the vehicle, and the officer approached and smelled a strong odor of marijuana. The officer asked the defendant to step out of the vehicle and saw in plain view a scale in the driver's side door, and the officer detained the defendant and the driver. Marijuana was 1.27 ounces.
You're telling me he saw him do a hand-to-hand transaction or someone else?
The driver of the vehicle was a hand-to-hand transaction, and when he approached the vehicle, he asked the defendant and the driver who did the hand-to-hand transaction to exit. And furthermore, the officer smelled an odor of marijuana.
I know, but why would he search him?
The officer's own attorney ultimately sealed his downfall, admitting to the judge that the passenger had no role in the alleged deal. He was simply sitting in the car, yet they still hauled him into court.
I get it on the driver because he sees the hand-to-hand contact with them, but he's just sitting there.
The only thing would be officer safety, just the pat down.
All right, Mr. Barnes, I'm going to find no probable cause. Just be careful, all right? Really. You hang with dogs, what happens?
You did.
No. Well, you get fleet. Well, you can get bit too, right? Please.
It's a bad dog.
Just don't hang out with the wrong people, all right?
Yes, sir.
Come on.
The judge wasn't swayed by a single argument. He cut through the noise and declared they had the wrong man, plain and simple. This next officer thought the system would protect her, but instead, it exposed her for the world to see.
No permission. No probable cause to search. Okay. Well, why are we still here?
Up next, we have a courtroom moment where an officer is pressed on her decision to conduct a stop, and her answers raise even more questions than the stop itself.
Good afternoon, Your Honor. Abigail Wilson on behalf of the people.
And Attorney Luke Goodrich from the Public Defender's Office, here to represent Ms. Robbins, who is standing to my right.
Today was the date scheduled for preliminary examination on carrying a concealed weapon. Are we ready to proceed?
The people are ready, Your Honor. Thank you.
Yes, sir.
Any preliminary matters before we call witnesses?
Not from the people. Officer Burkett, where are you currently employed?
City Land Police Department.
And what is your job title?
Police officer.
What are your general duties?
Respond to calls for service, self-initiated activity, and officer fighting role.
How long have you been a police officer?
With Lansing, it'll be 2 years and 14 days. And overall, I think I've been licensed for about 3 years.
Okay. Now, were you working as a Lansing police officer on December 12th of 2024?
Yes.
And what was your assignment on that date?
Road patrol.
And what were you wearing while you were working that date?
Full uniform.
And does that have police on it?
It does.
And were you in a car, on foot, or something else?
I arrived in a fully marked car.
And is that department issued?
Yes.
Now, on that December 12th date, you said you were dispatched for a personal injury accident, is that correct?
Yes.
And by that, do you mean a motor vehicle accident?
Yes.
Okay. Now, when you arrived at that location, what was happening?
There was a car in the northbound lanes of Penn, slightly in the road, that appeared to have collided with the curb and then a truck.
The questioning started calmly, but what came next would flip the entire courtroom upside down.
Were you able to make contact with anybody involved in that accident?
Yes.
Who?
Sierra Robbins, the driver.
And do you see Sierra Robbins here in the courtroom?
I do.
Can you point her out and describe something she's wearing?
She is in the black knitted sweater.
You needed to speak with her?
I did.
What was that conversation?
I can talk to her about her bloody nose for a little bit, got her license, and then we did talk about insurance.
And what happened when you started talking about insurance?
To my recollection, I began asking where it was at. She told me the glove box. To my, again, recollection, I said, do you mind? She was interrupted. She said, go ahead. I went into the glove box, and at that point I found a firearm.
And do you remember what kind of firearm that was?
It was a revolver.
Do you recall if Ms. Robbins had a CPL?
She stated she did, and she did not.
And were you able to run a law enforcement check on her?
Yes.
Did it come back as her having a CPL?
She did not, no. I had Ingham County lead run that.
Okay. And did she acknowledge that the gun was in fact hers?
She said that her dad bought it for her under her dad's name.
But she knew that it was in the car, is that correct?
Yes.
This is where it gets intense, as now the defense attorney steps in, ready to dismantle the officer's justification piece by piece.
And you recognize that this is the report that you wrote back on December the 12th?
Yep.
And when you do a police report, do you essentially kind of go off memory, or do you go by like the notes you take on scene, or how do you do that?
All of the above.
And do you remember specifically in this case, did you use all of the above?
Yep, I used my memory and the notes on scene. This report was written shortly after the accident was.
Body cam video on that day?
I was running code there, and so with the way our cars are set up, it automatically turns our body camera on while we're running.
Okay, so your body cam was clearly running throughout this entire situation. Is your testimony today that essentially Ms. Robbins gave you consent to search her glove box prior to you going into her car?
Yes, in the way I perceived it, yes.
Was there another vehicle involved in this?
No, she says she hit the ice back here, and obviously you can see she definitely came up through.
Is this her?
This is her here.
Sounds like she's.
Okay. Officer, is it, after seeing this video, is it clear that you actually had contact with Ms. Robbins prior to her being in the ambulance on this occasion?
Yes.
I came from back there. Why don't you get in our ambulance up and check you out, and I'll come to you in a second.
Okay. With you having seen now your first contact with Ms. Robbins, did she attempt to essentially tell you about the scene, about what happened with the car?
Yes, but I prioritized her injuries rather than a statement at that time.
Okay, so you sent her away to the ambulance.
Yes.
And so there's been no consent to search the vehicle at that point, having what you've seen there?
Then comes the turning point. The defense attorney plays the body cam footage, and the officer's actions speak louder than her words.
And officer, is that you opening the car door, opening the glove box, and starting to pull materials out of the glove box?
Yes.
Okay. And then officer, is that you proceeding to essentially kind of search through the center console of the vehicle at that time?
Yes, but not for any criminal reasons.
So you said not, you searched the console, you said?
Yes, I only search the places that are people most commonly hold their insurances.
Okay. Okay, and that would be the moment that you found the firearm in the glove compartment?
Yes.
So after, I guess, seeing this video, is it now your testimony that you did not speak with Ms. Robbins at the ambulance prior to going into that car?
Correct. After seeing this video, it is refreshed, yes.
And it is also your testimony that you had no probable cause of a crime being committed on scene?
Objection, Your Honor, that is a legal conclusion.
Your Honor, I'm asking what her reasoning to search the vehicle.
No, she can make a determination as to whether or not there was probable cause to search.
It is our policy and procedure that whenever there's an accident, we get license, registration, proof of insurance. At this time,
The question is whether or not you have probable cause to search.
no.
And based on the video you've seen now, you did not receive any consent from the driver to search those areas of the vehicle, is that correct?
Busted. No matter what she was after, this cop had neither probable cause nor consent to search, and the body cam proves it.
And this video was a fair and accurate representation of what went on?
Yes, this is what happened.
Then, officer, at some point after this, you go and speak with Ms. Robbins in the ambulance, make sure she's okay at that point?
Yes.
And then she was released on scene?
Yes.
No further questions, Your Honor.
I didn't read it right.
Thank you, Your Honor. Officer Burkett, do you know what happened with the vehicle after this accident?
I don't recall.
Okay. And are you aware of any requirements that individuals carry insurance when they're operating a vehicle?
Yes, it's law.
Okay. And you said, I believe on cross, that it's routine for your department to ask for that insurance. Is that correct?
Yes.
And was that your purpose in going into the car, was to confirm that there was in fact insurance?
Yeah, if she's being evaluated for an injury, there's a chance this vehicle is gonna be towed.
Well, strike that. There's no question. You know, but I have a question now.
Yeah.
Because maybe I missed something. You testified on your direct that she gave you permission to go in the glove box. She told you that the insurance was there.
Yeah, this was prior to being arrested.
Okay, so the video we shows after that she never told you that she had insurance in the glove box.
Right.
And so you went and opened the door without her permission.
Right.
And went in the glove box.
Right.
And then went in the center console.
Right.
No permission.
Right.
No probable cause to search.
Based on the testimony here today and the evidence, we are at this point not requesting bind over on this charge. Thank you.
Case is dismissed. You're all set. We'll get you a dismissal.
And just like that, the case was dismissed. How many lives get destroyed by lies like this? They write one thing in the report, swear to another in court, and then crumble the second video evidence appears. Absolutely shameful. This officer's arrogance quickly crumbled when the gavel came down harder than expected.
I took photos of a female that I arrested.
Why would you plead no contest to a charge of disorderly conduct for having done that?
I guess I broke policy and...
In 2014, Officer Brian Pergandy was accused of disorderly conduct after snapping disturbing close-up photos of a woman he had once arrested, and now he was about to face the consequences.
Pergandy, if you give up all those rights today and thereby give up the right to have a trial, there's never going to be a trial in these matters, sir, and instead we are going to resolve it all here this morning. You understand that? Mr. Pergandy, you're joining with your lawyer, sir, and pleading no contest to this disorderly conduct charge back from September the 8th, 2009?
Yes.
What is it specifically that you did that you're causing you to plead no contest to disorderly conduct here today, Mr. Pergandy?
I took photos that were eventually blown up, I believe.
What?
I took photos of a female that I arrested.
Why would you plead no contest to a charge of disorderly conduct for having done that?
I guess I broke policy and I guess I made her feel uncomfortable, Your Honor.
Why would you have made her feel uncomfortable, sir?
I don't know. She was fully clothed.
The judge wasn't about to let this slide. He grilled the cop and escalated the charges to a felony trial. He came in thinking he was untouchable, but the judge wasted no time reminding him he wasn't above the law.
Found the defendant Aaron York deemed guilty beyond a reasonable doubt of the offense of manslaughter. Assess his punishment at confinement in the Texas Department of Criminal Justice for 11 years, 10 months, 12...
In this next case, justice comes knocking for Aaron Dean, a former cop who shot an innocent woman through her bedroom window, and he's finally facing the consequences. And now, he's about to be charged with one of the most shocking and senseless murders you'll ever hear about.
Verdict reads, we the jury, having found the defendant Aaron York deemed guilty beyond a reasonable doubt of the offense of manslaughter, assess his punishment at confinement in the Texas Department of Criminal Justice for 11 years, 10 months, 12 days. They do not assess a fine. And it is signed by the presiding juror. You may be seated. Thank you very much. Juror number 1, is this your verdict?
Yes, Your Honor.
Juror number 3, is this your verdict?
Yes, Your Honor.
Juror number 4, is this your verdict?
Yes, Your Honor.
Juror number 6, is this your verdict?
Yes, Your Honor.
Juror number 9, is this your verdict? Verdict. Juror number 38, is this your verdict?
Yes, Your Honor.
Your verdict will be received and filed. Thank you very much. Mr. Gill, Mr. Brissett, is there any legal reason why sentence should not be pronounced?
No legal reason.
Mr. Dean, it's the jury having found you guilty of the offense of manslaughter and assessed this punishment. It's the order of the court you be remanded to the custody of the sheriff, be delivered to the director of the Texas Department of Criminal Justice to serve your sentence as required by law. You will receive credit for all the time that you have served in custody on this case. If you are indigent and cannot afford a lawyer, I would conduct an indigency hearing to determine if you are indigent. And if you are indigent, I would appoint a lawyer to represent you on appeal and provide you a record of this appeal of this trial at no cost. Is there an allocution? You may be seated. Thank you very much.
After all that, Dean escaped a murder conviction and was sentenced to just 11 years for manslaughter, and many say that's a slap on the wrist for such a shocking crime. The courtroom quickly turned into a lesson in humility when this officer realized the badge doesn't shield you from justice.
Felony of armed criminal action I sentence you to a term of incarceration of 6 years in the Missouri Department of Corrections.
On December 3rd, 2019, a call about a man chasing his girlfriend ends in tragedy. As the suspect pulled into his driveway, Officer Eric DeValconaire ordered him to step out of the truck. When he didn't comply, DeValconaire fired twice, killing him instantly. What followed was a murder charge and a trial that kept everyone waiting for the verdict.
No matter what I hear, I will only consider factors that are appropriate and that I will disregard those that are inappropriate. And that is what I've done here, and as a result, I've concluded as follows. There are a number of facts in this case that are both aggravating and mitigating, sometimes all at the same time. First and foremost is this undeniable and uncontested fact. Cameron Lamb is dead, and Eric DeValconaire killed him. That's undisputed. Cameron Lamb was by all accounts a helpful and loving son, brother, father, and friend. People who have contacted me and who I have heard from today have described him as funny, caring, giving. Miss Gray called him a protector, a jokester, and my favorite of all the ones that I read, not a saint, but our angel.
The judge didn't hold back and lectured the disgraced officer in open court before delivering his final ruling.
Cameron Lamb's death leaves an irreparable and unfillable void in the lives of his family and his friends, and also in our community. Also, as I'm weighing all these facts, it can't be overlooked that the events of December 3rd of 2019 were initially set into motion by Cameron Lamb and his decision to chase his girlfriend through city streets at dangerously high speeds, putting motorists and other members of the public at risk. However, those events tragically concluded with the actions of Troy Schwam and the defendant. Sergeant Schwam pulling into the driveway, immediately getting out with his weapon drawn, rapidly moving into the backyard, carport, garage area of the house, and defendant doing the same. Both without taking a breath, without pausing for the briefest of moments to consider where they were going, what they would find when they got back there, whether they were acting lawfully in doing so, and whether there might be some other safer option, without so much as a, "Hey Troy, wait."
The truth was undeniable. Cameron Lamb wasn't even reaching for a gun when the officer pulled the trigger. The judge laid out every detail as the disgraced cop sat there.
At any point, Sergeant Schwam and the defendant could have done this. A fact that is made even more aggravating as the court considers an appropriate sentence in this case by the fact that the one person who ultimately did take a breath that morning was Cameron Lamb. He did this when at some point, while he was chasing his girlfriend, he decided to discontinue the chase and to go home. The video from the helicopter shows this decision, shows how it played out. Cameron Lamb is not racing through the streets of his neighborhood at this point. He's not driving through yards to get away from anyone. He does not abandon the truck and let it roll into someone's yard while he flees on foot. Rather, he simply pulls into the driveway of his home, pulls around back, puts the vehicle into reverse, and slowly begins backing it down the driveway under the carport and into his garage. Sergeant Schwam and Eric DeValconaire arrive, and as the court has found, an encounter that was over and a situation that had de-escalated was again escalated by what I have found, rightly or wrongly, was their unlawful entry into the backyard carport area and confrontation of Cameron Lamb. This is an aggravating factor. Cases of the offenses described during the trial, however, also provide the court with a mitigating factor. I found, as I've considered the evidence in the case, that the defendant, Eric DeValconaire, testified credibly at trial that he was rushing to provide cover for Sergeant Schwam, who had rushed into the backyard with his weapon drawn, prompting the defendant to do the same from the other side of the house. Although not in the court's view, again, rightly or wrongly, negating his obligation to act with reasonable care, as the court found he has failed to do.
This wasn't policing, it was tyranny. Officers overestimating their power, invading a home illegally, and leaving an innocent man dead in his own home.
Natural reaction to protect his partner is a factor for me to also consider. And let's also be clear, and it is hard to accept this distinction. I know that. Murder and involuntary manslaughter arising from criminal negligence are two different things. They are different legal concepts. They are different things. Eric DeValconaire is not Derek Chauvin, who murdered George Floyd. Eric DeValconaire is not one of the 3 men in Georgia convicted of running down and murdering Ahmaud Arbery. This is a mitigating factor. Defendant has no prior criminal history. His ORAS scores him as a low risk in all categories. Defendant's history as a police officer, husband and father, friend and colleague is also a mitigating factor that I have taken into account, as his father asked me to do, which I was already going to do, and that is to consider the totality of the circumstances and to consider the totality. And the circumstances in the history of defendant's career and his life that have been presented to this court have demonstrated he has not hesitated to immediately take action when he believed the circumstances surrounding him warranted it. And this trait has generally served him and others well. It also failed him, as it did on December 3rd of 2019. All of which, however, leads the court back to where it began, an evaluation of the impact of the defendant's crime on Cameron Lamb and his family.
What made this case sting even more was the judge's decision to side with the suspect, despite the evidence pointing to yet another clear-cut killing.
Cameron Lamb is dead. Eric DeValconaire killed him. And the court has found that that happened because the defendant acted without considering or being aware of the substantial and unjustifiable risks associated with his conduct, and that his actions were a gross deviation from the standard of care that a reasonable person would exercise in the situation. Having concluded, as I have, having considered all those factors, I ask counsel if there's any legal reason or cause having been shown why sentence and judgment of the court should not now be pronounced. Eric DeValconaire, on count 1, the Class E felony of involuntary manslaughter in the 2nd degree, I sentence you to a term of incarceration in the Missouri Division of Adult Institutions of 3 years. On the unclassified felony of armed criminal action, I sentence you to a term of incarceration of 6 years in the Missouri Department of Corrections. Those cases, or rather those counts and sentences, will run concurrent with one another for a total term of incarceration of 6 years.
Eric was found guilty of murdering Cameron Lamb, yet he walked away with just 6 years. The reduced sentence makes one thing clear: he was protected because he was a cop. Well, that brings us to the end of this video. Today, we witnessed some shocking moments where corrupt cops were finally held accountable and publicly humiliated in the courtroom. These officers abused their authority and thought they were untouchable, but the judges made sure justice was served. Thanks for watching. Please support the channel by subscribing, leaving a like, and comment if you want more like this.
Actually, we can trespass you from here. They can. Yes, I can. Give it a try then. All right, let's be done with that.